Welcome back to another edition of Between Two Fars. I'm Warneke Miller, and I am joined by Judge Reid Prouty, Vice Chairman at the Armed Services Board of Contract Appeals. We're going to start a mini-series here talking about attorney-client privilege, attorney work product privilege, and how that impacts you during trial, during your case. What's discoverable, what's not discoverable? How do you proceed and present issues regarding privilege before the board? I know this is something that has really been pertinent in some of our other cases and something that we all hold near and dear to our heart, because this is our work product we're talking about. This is our conversations with our clients, and we tend to get a little territorial on this issue. So why don't we just take a step back, dial back the emotion a little bit, and talk about this from a pragmatic point of view. How does this come before a judge, and what is the most professional, most effective and efficient way to deal with these issues? That's a big topic right there. So, are you ready for this?
A little bit.
All right, Judge Prouty. Well, first of all, just high level, how does the ASBCA treat these issues of attorney-client and attorney work product privilege?
We treat it just the same way that the federal courts do. So if there's not board precedent on point, which I'll talk to about in just a second, we'll look at the federal thirds, the federal subs, or any other reporter that is appropriate as far as giving persuasive authority. Of course, the Federal Circuit case would bind us, but the Federal Circuit doesn't have a particularly large number of cases involving attorney-client privilege, but the other federal courts do. And although they're not always coming to the exact same conclusion, the rules in general are pretty much the same across the board. I will say that the board does have some precedent on the issue. A few episodes ago, I should say, I talked to you about how the board, 3-judge decisions on merits matters are precedential. And normally, for decisions on things about discovery and whatnot, they're not precedential. It's a single-judge decision. But on occasion, we issue a decision with 3 judges on a discovery matter to make it precedential so that you'll sort of see what the board law is on a particular matter. We've done that on 1 or 2 cases involving privilege, and there may be a few more as time goes on because we would like there to be instruction out there for the board to see. So there may be a board decision on point, but there probably isn't. And if there isn't, go to the same sources that you would if you were in the Court of Federal Claims or a district court or somewhere else. And that will begin to inform you how we'll approach it.
All right. Are you ready for another loaded question?
Sure.
All right. When can we rely on these privileges to be able to withhold documentation from discovery?
Sure. Again, you can apply the same rules you would anywhere else. I will say one thing that's important, and sometimes government counsel aren't as good about as they might otherwise be, is you need a privilege log. And actually this applies across the board, both sides, both the contractor side and the government side, need a privilege log. So if you're going to withhold a document that would be responsive, and a lot of the very best stuff that you don't want to hand over is responsive, you have to have a log sort of saying, here's the document, here's who was on it. So you can sort of, enough out there to indicate why it's privileged and the basis for your privilege. And of course, your opposing counsel is going to look at that immediately and decide that's what they want. But you got to log it so that we know, so that it's identified as something subject to the privilege. And having a good privilege log, by the way, is really important to you, because if you do a less than fulsome job on it, it is much more likely to be the kind of thing that, well, the privilege log isn't good enough. Either if it winds up in front of us as a motion to compel or something like that, if it's not a good privilege log, there's a much better chance that A, I will order the government to do a better job of a privilege log, or B, fine, you know what, I'm going to review the thing in camera. And obviously, part of the whole idea of privilege is you don't want that in front of the judge. And if I'm going to review it in camera, of course I'm going to do my best to divorce what I'm reading in camera from what I decide later on in the case. But obviously you prefer me never to see it in the first instance. And I would prefer, frankly, not to have to spend my time reviewing documents in camera. So pretty important to you to have a good privilege log.
Yeah. And I'll just pause here for a second and refer our viewers over to the fantastic episode we did on privilege logs with Paul Kim and Dave Schumann, and I'll put that episode location down there. And if you want to know more about privilege log, please take a look at that episode.
Good to know that you had one. And I'll just add that, sometimes attorneys have their sort of reflexive view that if it's email from me to my client, there's no way it's not privileged. The problem is that it's not just from an attorney to a client. It has to be talking about things that are confidential and involve sort of legal advice. And so, what happens, for example, when an attorney is involved in writing a COFD, which happens all the time, at least on the government side. And what happens when you have track changes where there's a whole slew of people who are involved in giving intake on a COFD? Does the fact that one of the people on the receiving end of that be an attorney, does that mean that that's privileged? It's actually not quite as clear-cut as you might think. There's a lot about things to be balanced and consider. So you can't just have a knee-jerk reaction that because an attorney is one of the people CC'd on a huge email, that it is going to be automatically privileged. Because after all, it's shared with a lot of people, and not necessarily being asked for legal advice. And especially attorneys do things that aren't always purely legal advice. Sometimes they're just sort of staffers, so to speak. And is that protected by the attorney-client privilege? In some cases it is, in some cases it might not be. So I'm sorry to say, the rules aren't quite as black and white as we would like. And you shouldn't feel that automatically, just because an attorney is on it, it's privileged. Flip side is, you need to be careful about waiver as well. Because once you start giving away things that an attorney is emailed on, you risk waiving that privilege. Again, it's messy. You need to give it some thought before you assert the privilege, and you need to know about that.
All right, I'm going to hopefully not surprise you too much with a question we hadn't talked about before, but a lot of times the parties are able to sort of structure their own discovery and have an agreed upon order about what's going to be considered responsive to discovery requests. Have you seen any effective methods early on where attorneys can agree how to address privilege issues? I have always kind of wondered, hey, could we get opposing counsel to agree that if an attorney is CC'd on it, we'll just have a gentleman's agreement or a ladies' agreement that we'll consider that privileged and we're not going to fight about that. I've not successfully been able to pull that one off yet, but I was wondering, have you seen any agreements of that nature to make discovery run a little bit more smoothly, and what sort of things might counsel agree to early on that would help circumvent some of these problems?
Frankly, I've never seen that.
Yeah, all right.
So I just can't.
A girl can hope.
You wish. And wouldn't that be great? I will add that sometimes people definitely have an interest because your opposing counsel may well have emails that they don't want to hand over either.
Right.
So you may have a sort of a goose and gander sort of agreement about the kinds of things that you're not going to be providing. I will add that does bring up the issue of a clawback agreement. And there's no reason why you shouldn't have a clawback agreement. And if you're doing massive discovery, you probably should. Yeah. And if you don't already have a segment on clawback agreements, basically the idea is that you have an agreement with your counsel that if there's an inadvertent disclosure of attorney-client product and you discover it afterwards, it's not waived. You as soon as you know about it, you let them know, and they have to give it back to you. And the same usually applies on both sides. And when you have massive discovery of electronic databases, it is easy for these things to happen.
Yeah.
And having a clawback agreement to protect yourself from the waiver, and the other side to protect itself from the waiver, is pretty much a standard part of discovery practice nowadays.
It's still got that in-camera problem where, hey, they've seen it and they can't unsee it, but at least it's not going to be part of the record that the decision is based upon. Well, this is just getting started. We have so much more to talk about when it comes to attorney-client privilege and attorney work product privilege. So why don't you come back here again and watch the next episode of Between Two FARs.